Security. Oh my god. Shit, security, we missed you so much. Security, how are you? Oh gosh, please say you're okay. I'm okay. It was just life. Security wasn't in jail. No way, she's security. Security, we missed you so much. We missed you so much. We are so glad you are here. I hope you're doing great. Great. I can't believe that you're here today. I can't believe that you're here today after the day we had yesterday, guys. After the day we had yesterday, security's here. We saw Maiko yesterday. Yep, Maiko's back. Maiko's not in chat right now, but Maiko's back. We got security and Maiko back. I don't even know what to say, guys. I don't even know. I hate moving. Yeah, Bobby, I have a Halloween costume. Yeah, no, it's not Elvira. You don't know what it is? You don't know what my Halloween costume is with black hair? It's a bunny. I'm gonna be a bunny. I needed black hair for my bunny. I got a party to go to in a couple days. Halloween party. So, I'm going all out. Yes, sir. And guess who's in charge of the food? That means it's going to be a great Halloween party. And by food, I mean, drinks. We have this stuff in Lancaster that you can't get called Jimmy Juice. And that's going to... I told everybody I'm going to bring food. All the food. You don't have to worry about food. Instead, I'm just going to bring a bunch of Jimmy Juice. Your dinner is served, guys. Just kidding. I'm going to put the food in the car and hide it. I'm not bringing the food in, though. I'm going to bring in the Jimmy Juice. And then a little later, I'll bring in food, I guess. Yep. Oh, security. Okay, where are we? What are we doing? What the heck's going on here? It's not beer though. It's Jimmy Juice's like vodka cranberry stuff. So good. Oh my gosh. So we're on part 2 of the second session. For the new people here, this is a judge that's in trouble. This is not something we normally do. So, the judicial review committee or whatever are the 3 judges sitting there, and then the guy with the white hair on the left is the judge that's in trouble. He's in the witness box, and he was very slow on some of his cases that he was working on. I don't know what else they put in it. It's delicious. So probably something really bad for me, like I don't know, cocaine. I don't know. But broken hip. So yeah, Jimmy Juice. Ooh. Actually, it's gonna be a fun time. So, let's get started on our poor judge.
Is there anything? Is there any reason why the court has not been able to reschedule that trial or move that case forward?
Yes, sir. See, this is one thing that does concern me about Wendy's list is it doesn't get into the weeds on why maybe something's not being done. That's a petition for letters of administration where you've got 3 heirs, a wife, 2 children. I suspect that's the second wife, and It was scheduled for trial, and trial was supposed to be on June 18th. Oh, when I think the children, the two sons objected, the spouse filed her response. I think this is right. I may have the details wrong, but said, oh, those are just purported sons. So you get into, well, are they heirs or are they not? Do they qualify as children? And a week, the trial was scheduled for June 18th. On June 13th, the petitioner filed a petition to determine heirs, saying, oh, well, we need to figure out who the heirs are. And obviously, before you can have a trial on an intestate estate, well, even a testate one, you've got to determine who the heirs are. So I couldn't hear it. I vacated it. She hadn't served the sons until, as a matter of fact, when they showed up for trial, they hadn't even been served with the petition. She, the spouse, the wife, hadn't been served. She had not served the sons yet. They find out at trial, evidently, that there's this other petition out there, so I had to vacate it, and I put in the order, the trial is off, subject to being rescheduled at the discretion of the court and at the request of any party. That part's left out, which is a kind of important part. I'm not trying to avoid that hearing. I'm not trying to not schedule it, but you've got to determine the heirs before you can have that trial. Until after the trial was already scheduled anyway, I don't think the issue of whether they were heirs or not was an issue. But I can't go forward yet until the petition to determine heirs is resolved. But it's not me not doing my job. It's not me dragging my feet on this. And why that case was picked out, I have no idea.
Let me ask you about the two Goldberg cases. One is listed at the bottom of page 1, and there's another one listed at the top of page 2.
Yes, sir.
It appears both are listed at, are these the same case?
No, sir. One's a husband and one's a wife who passed. They're two separate estate cases.
The one at the bottom of page 1, which is a little difficult to read because of the certification stamp, but that Goldberg case is listed as needing an order appointing personal representatives. Do you see that?
Yes, sir. That's the Lynn Goldberg file, 1355.
Lynn Goldberg. Is there some other motion or other action that the court had to act on before that could be taken up?
Yes, sir. This is a case, well, these are two cases. They're basically companions to each other. They're husband and wife. They died. They both have wills, apparently. And the will names the two children, sons again, I think that's right, as being the co-executors. And one says, all right, I want to probate this will, but I don't want the other as the co-executor. You should deny that. And when that happens, you have to have a hearing on it. And they filed requests for admissions and some other things. The petitioner did. And they filed a motion for summary judgment as to that. So the list doesn't mention anything about the motion for summary judgment. That was had to be acted on. The staff attorney did handle that, entered an order on that, and now it is ripe for a hearing because I denied the motion for summary judgment. They filed a motion for reconsideration even as to that. And
Kelly, thank you so much. Thank you, Kelly. I appreciate it. I do. Yes, Carlos, going to a Halloween party. I need black hair for that.
and we and we had The other thing I did in that case was we went ahead and had a trial set for the probate of the will without deciding the issue of who should be appointed as the personal representative. So we had that. One of the sons, the petitioner showed, the other one did not. So I entered the order admitting the wills to probate and solemn form. And the only issue that remains now that I think there was a second motion for summary judgment filed as well. Yeah. In July, there was, I believe, a second motion filed. That's been ruled on
Yay,
now. So
thank
yes, it's
you.
ripe, and yes, I've set
Thank
a
you,
hearing
thank
very
you.
recently
Now I'm going to get coffee.
for a trial. That's set for trial December 2nd. But, and it'll be heard as to who should be appointed. And maybe I'm going into all this detail is because I want you to understand, these cases aren't just sitting there. Stuff is taking place.
Let me ask you specifically, I'm sorry, go ahead.
Judge, I appreciate the context and the explanation. Did you ever have these discussions with Judge Williamson when she would hand you these PDFs with these cases cited on them? Did y'all sit down, go through them, and see why things weren't being ruled upon, and maybe have a discussion about formulating a plan, and maybe saying, hey, perhaps this one shouldn't be on the list for the reasons you're now giving us? Have you ever had those discussions with Ms. Williamson, or Judge Williamson? Excuse me?
No, sir, and certainly haven't had to these four that were added.
Sure.
But
Don't you think that would have helped, at least, have some communication internally within your office? And I understand that what you've testified to previously is that you really don't talk to Judge Williamson and whatever conflicts may exist there. But as the head of the office, if you have a good administrator and someone who can also she has the ability to work on cases more as a judge as well, wouldn't you want to sit with her and at least try to formulate plans to make sure that cases aren't ending up on this list? Or if they are on this list, let's talk about how we can tackle these, or why they're on the list. Perhaps they need to be on the list because I can't take action for whatever reason, for the reasons you're explaining today. Don't you think that would be a good way to run your office and see if maybe you can iron out some of the issues that are leading to some of these delays?
Commissioner, before he responds, can I just point out that this was a list that he did not have access to until the JQC requested it. No one had seen it because it hadn't been
Yes, but he's
produced.
had other lists. He's had access to the list. He's been emailed previous lists.
You mean that specific?
Sure,
Yeah, I
but
understand it's not this specific list, but I'm asking a question about process in the office, because I know this list has existed for a long time.
What do you mean he didn't have access to the list? I thought this is the list that's just in the shared iDrive.
it is stored on the shared drive that he has access to. So he had access to it in the sense that he could, if he could figure out how to do that, go and access the Excel spreadsheet, but it had not been produced to him as.
I mean, I get that the last one he got was June.
Correct.
But nobody was hiding it from him. I understand his
No, but
logical limitations.
I guess the point that I'm trying to make, Judge, is that it's, that's right. The list as it exists on the shared drive is constantly being updated, changing. It's constantly changing. When it is presented to him, it then is presented essentially as, okay, this has now been verified or compiled, and we are now representing, or I guess Judge Williamson is representing in her capacity, that this is now, these are the orders that we need action from you. So he did have access to the Excel spreadsheet, but the original agreement between he and Ms. Williamson was that she would prepare this and produce it to him on a monthly basis, that they could sit down and go through the list together. That's not how that has played out.
Gotcha.
And
Well, that's what I'm asking, is why not? I mean, if it's being updated monthly or weekly or however often it's updated, why aren't there being discussions about the cases that end up on the list? And and creating and formulating plans for resolving them.
If I may, just a moment. On August 26, the staff member looked at the list and it showed one thing. On August 27, 4 cases were added that we're talking about here. And I don't think they were just automatically added. I think they were purposely added. I don't know how to.
And I understand that. I'm just trying to understand whether it's the August 26th list or the August 27th list or the July 27th list. Like, you've always had the ability to A, pull that list down and look at it, or get someone to, a staff member to print it for you and look at it. And B, to Mr. Lopez's point, just have a conversation and say, all right, time to look at the list. It's been a month or two. Right? I mean, but y'all don't have that
No, ma'am. And
conversation?
it's a very, very difficult working relationship. And yes, she does work for me, but I can't make it a better working relationship given how she is and how I am, I guess. And I hope this doesn't sound wrong, but I spent all day yesterday going through that August 27 list and going through what has happened in each of those cases. And that took time, a lot of time, that could have been better spent working on some of those cases or some of the other cases, some of the unlisted cases. And I don't think it's the best use of the time, given the circumstances, for me to have to go through that and say, oh, well, Wendy, you overlooked on the Goldberg case, X, Y, and Z. I think she has her agenda, and I don't know that but I think she's got her own plans, and I think your concerns are valid, and I wish I could do what would be the common sense thing to do, but I don't think it would be productive. And without getting, and I'm not charged with that. I'm not charged with not talking to Wendy. I'm not charged with her not talking to me. And I'm not charged with I don't think any of these cases on here. And I realize it's a complex problem, and the solution's even more complex. But
And I think that's sort of what we're getting at is, you're right, you're not charged with these. And so, I mean, we've gotten a little off message here. But I do think the one thing is that this conversation we're having sort of helps either illuminate or doesn't for us is, I think you just said it. It sounds like it might be a complex solution, particularly given the work environment that you all have created. And so, I mean, if y'all aren't willing to sit down and talk, and y'all don't agree what should or shouldn't be on the list, and then it sounded like, I thought I understood from the first email, P5, that all the different clerks were supposed to be all dumping stuff into this one iDrive spreadsheet so that everybody sort of knew what was going on. But then I thought I understood you to say that Wendy doesn't know what's on your desk or what the other 18 clerks give you. So it sort of sounds like even the other clerks aren't using this like they're supposed to, I guess. So, I mean, it sounds like there are files everywhere. I'm just trying to understand how we...
I would be very clear about something, and maybe the trial process doesn't work real well on this. We are not a dysfunctional court. We are doing, I think, an incredible job with the workload that we have. And I think that's almost every single person who works at that court, including Wendy. We are struggling in many ways with the past. You know, with things popping up, cases coming in, saying, what's happened since 2013? What's this unfiled order? And we're dealing with that, but we do a darn good job with dealing with the cases. We, you know, at the last hearing, the lawyers said, oh, well, you know, probate courts, you know, slow. They're slower than they used to be. We are. And I thought, well, why is that? And it's not that hard to figure out. We are processing cases. We are actually reading the petitions when they come in. Those cases I mentioned from 2013, 14, 15, they should have been, had a deficiency notice go out the next day saying, you haven't named the heirs. You've got to, excuse me. You haven't named the heirs, you haven't done this, you have to do that, and you've got 30 days to do it. Instead, in one of those cases, a hearing was scheduled 6 months later and a week before, they realized, gee, we don't have the right heirs, and it got.
How often do you discover an old case like that? Is that a once a week thing, a once a day thing, a once every few weeks kind of thing?
I don't know how to answer that. It's not unusual, but no, ma'am, it's not every week. You sometimes see things in cases that I can't believe. You know, you get some of these 2015 cases, they pop back up because by their nature, they're ongoing. They're guardians or wards, they're guardians or conservators that have to report, where no one's been reporting, no conservator's been reporting for 10 years. And we've got a specific deputy clerk going through those cases to say, all right, well, what's going on in this case? Why we need to pull this conservator in and ask what the status is. We are working better. We have a far, far better court now than we did 10 years ago, 8 years ago, 5 years ago. And I'm proud of us. And this, you know, fly-specking each of these cases makes it, oh, well, you're not doing your job. The court's not doing its job. That's simply not valid, not accurate. And I think Wendy would say she's proud of this court. I am very proud of this court. I'm proud of what I do. I'm proud of much of what Wendy does. And we've got a terrific staff. And so I care desperately what y'all say and do about me, but don't go away with the idea that this isn't a court that's working very hard and very well.
Judge Perdue,
Yes, sir.
as I read this email, it's P5. It's dated November 2nd, 2021. So this is quite a while ago. As I read Judge Williamson's email, I see this as an effort to try to organize the office and try to make it more efficient and try to get everyone on the same page. You know, she's creating an iDrive, a document that everyone can access. She's asking people to put information in there so you don't lose track of cases and we know where the cases are and where they're physically located. And she finishes with, I know these are additional steps, but it will consume far less time than searching for a file, and it will help us prevent files from falling in cracks. So as I read this, I see someone who's trying to make y'all's office more efficient, better in every which way. My question to you is, you've alluded several times to her having some agenda. Do you think she had some agenda when she created this spreadsheet in 2021, other than trying to organize your office?
No, sir.
Thank you.
What is it that you think her agenda is that's underlying now?
If I'm left as the judge, I've got to go back and work. And I'll answer that if you really want me to, but if that's really part of this hearing, but I don't think that is going to be conducive to
Well, I mean,
continuing to work.
you're just sort of, I mean, she's obviously a critical witness, it sounds like, for the director's side of things, and they're apparently planning to call her in rebuttal, and you've sort of talked around that issue. I'm just wondering, I mean, sort of maligning her motives or her, I don't understand. I mean, are you suggesting she wants your job, or, I mean, I know we've had that conversation already.
Yes, ma'am.
And despite the back and forth,
Abso-fucking-lutely, yes, she wants his job. Absolutely. Of course she does. Is she completely wrong? No. Is she doing it the right way? No. Is he right? No. Like, court case has been sitting around for 7 years. She's actually correct about that. But I don't know.
it seemed pretty clear to me she really did not want to do that, but it sounds like you have a different take on that.
Ma'am, I think she absolutely wants my job. I think she wanted me not to run again so that she could run and run unopposed. That I don't think she wants to have to run in a contested election. We've had discussions about that were not pleasant.
Oh, no, I remember that testimony.
Yes,
No,
ma'am.
so I mean, that's really what we're getting at, is your concern is that her agenda is that she wants to be the probate judge.
And I expect she will be one day. I mean,
She's
just
like 20 years his junior, maybe.
probate judgeships are not the most contested around. But, no, I think she wants to undermine me, and a lot of trust was lost with her when she went into my office and formulated that letter that's in admission, in evidence, and took photos. That's not to, help me. That's to document and indict, in my opinion. But boy, I feel like a divorce trial. We were watching all the dirty laundry. Y'all have charged me with not getting orders out timely for hearings that have been held. I've admitted to that. I regret that ever happened, and I think I have fixed that so that it won't happen again in the future. I have never refused to not do my job on those, and I've failed to do my job on the cases I've been charged with, but not because I was, lying out at the beach. I was working on a lot of other cases, and, I've got order after order here where I've done the job to keep them from being on. So, I don't know. I'm proud of the job I do. And y'all can find plenty of fault with it, and lots of people can, and lots of people have. And sometimes they have agenda, and I'm not just talking about Wendy, lots of people. And, but I know that this court does a better job by far than it was when I got there and when Wendy got there.
Judge Bordeaux, let me close the loop on these spreadsheets with a final question here about this. Looking at P3 again, do you have that still in front of you?
Again, that's the August 27 list.
Correct. The spreadsheet, and all the spreadsheets have the final column says months pending. And let's just speak generally here, not about any specific case, but generally speaking, is that necessarily accurate? Have you found it to be accurate?
Depending on what it's trying to measure. I don't, if it's supposed to be the number of months since an order was, a hearing was held and an order not entered, it is absolutely not accurate or valid. It tends not to be.
And that number, as you've talked about with specific cases briefly, previously, I should say, doesn't necessarily mean that no action has occurred in that case for that many months, correct?
Absolutely. I mean, I've read off the actions that have been taking place in some of these that have been pending for, according to this, for a long time, since the case was filed.
Including action from the court.
Absolutely. Hearings, status conferences, orders, the whole deal.
Judge Bordeaux, what do you think?
But Josh, I got this little thing that goes across the top. So when I'm gone and they cheer me, boom, everybody sees. Thank you guys. Thank you. Thank you. Thank you.
The hearing panel should impose as an appropriate sanction here.
I have 2 court-oriented mugs, too.
Add drama to it.
Yeah.
For whom the bell tolls. Oh, wait just a moment, please. I do not believe there's a legal basis for removing me. And the case that has just not been proven.
I'm sorry to interrupt. I think the court reporter is having.
Oh, I'm so sorry.
You can, Judge, you can bend that microphone, down up to your liking, just if you'll make sure you speak
Yes.
into it. Thank you so much.
Let me know.
Because
I
his
don't think the
name is
case
Charles.
has been proved that would warrant, justify legally or otherwise, maybe certainly morally, to remove me. I do a good job. I don't do a perfect job. I've not refused, not done my job, the spreadsheet on the hours that I've been there. Tell you that alone. Wouldn't make any sense to suspend me from doing my job. That just makes the problem worse. And I'm not sure what options are left for you, because if it's reprimand, then I've been embarrassed by the charges, by the sitting here, by causing this difficulty for y'all and for the JQC. I presume that you're not in a position to say, well, thank you, Judge, don't do this again, goodbye. I think you'll reprimand me. If you do, then I ask that you include in that language, however it works, to say, yes, this judge works his tail off. He's there, he's competent, he's not stealing money, he's not drunk, he's not showing up. He's working, and he's working hard. I've got a daughter, second year law school at Georgia. I'm very proud of her. And I want her to be very proud of me. And if y'all reprimand me and say, you failed, please at least say he was trying. And I want her to be able to read that and know that.
I'm proud of you, Judge. I am. I honestly am.
I'm sorry. I don't tend to talk about my children without getting upset, because I'm very proud. So it's not, I can't tell you what to do. I wish it would just go away. It doesn't work that way. Y'all can't just let me walk because the signal, it seems, that sends out that, oh, judges can not enter orders and escape. But I've been embarrassed enough about this. Yesterday, I got to watch my church service online while I was at the office, and the minister talked about.
Object to was about what the judge thinks is appropriate.
Response, Mr. Wilson?
I think he was trying to wrap up his thoughts.
If this goes to what you think is appropriate, then I will overrule the objection
It does.
for now. Go ahead.
The minister said that his mentor was, had a serious illness and had recovered from it. And he began his sermon, this other minister, with saying, everybody should have a near-death experience once every year.
My son does it once every day. Shit. Security. I'm glad, not that you got fired, terminated, whatever. I'm glad you don't have to do that job anymore because you talked about it before and it wasn't great for you. It wasn't.
And to me, I said, yeah, this is my near-death experience. I've learned from it. I've learned what has got to be done for the life I've got as a judge in terms of what cases need prioritizing and need action. And near-death experiences are hard, and this has been hard. It's hard on y'all because y'all are being put in a spot y'all don't want to be in either, I'm sure. But, you know, I don't know what your options are. It's up for y'all to decide. But I would ask for a reprimand and for a private one. I've learned, I know what I'm going to do with the rest of my judgeship. Time as judge. So,
I
Thank
don't
you.
want him to get a
Thank you, sir.
reprimand. How
All right,
about a probation?
Anything else for Judge?
How about just like the next 90 days, monitor his performance before you reprimand this man?
Bordeaux, may he step down?
Just one question. You said you realize and now recognize what needs to be done. And I guess properly prioritize the cases, correct?
yes, ma'am, within the highest absolute priority is when you have a hearing, get the order out on that, on whatever's to be decided.
What system have you implemented to ensure that you are properly prioritizing your cases that need action?
For the ones that you have a hearing on and you need to get an order out, it is in front of you, and if you hold off whatever else is coming in the door till you get it out. I had a hearing, a guardianship, conservatorship case contested last Wednesday. I hoped to work all day Friday on JQC, but I stayed until 9 o'clock that night, Thursday night, getting the order out because that had to be done. Those cases have to be done. And come heck or high water, they're going to be done.
What system do you have in place to track those cases?
Those cases are now few and far between, and they're right there. I don't understand what you mean. I have a hearing, and I have that case there, and it says, needs order. And I do it. And that's regardless of what has come in. And how late I have to stay to do it.
And what is your goal for how quickly you want to get those orders out?
Well, that honestly depends on the case and the order. If it's a day-long contested guardianship conservatorship case, that's one thing. If it's a week-long case that has unusual issues and lots of different facts, that's something else. I may ask the attorneys for their suggested findings of fact if there are attorneys involved. But if I don't know how to say, it's got to be within 24 hours, that often can't be. But they're not going to leave my desk. They're not going to be there. I will expedite them fully. as much as can be.
So that's how you're keeping track. You've got them physically on your desk, and they won't leave until you've done the work.
As far as I know right now, as far as I can recall, there's only one. I had the hearing in that guardianship case last week. No, it's probably been 2 weeks. 2 weeks ago, trying to remember the name of it, but I know it's there. I know the order has to be entered. I suspect I'll do it this weekend.
So the answer to my question is yes, you're keeping them on your desk until you get an order entered, and then you're moving them.
If yes, if not, they may be in the file drawer just for that. In a section of the file drawer just for that.
Okay.
But that's, again, we're not talking about many cases in that category. Thank you.
Nothing further.
Thank you. May he step down?
I have a question.
Yes, sir.
Do probate courts have a deadline on when to rule? If Mr. Wilson's correct, I'm sure he is. Is it just open-ended?
You mean statutorily? I don't know of one the way, I think the superior courts have a 3-month or 60-day or something like that ruling. I do not think that's required statutorily for probate courts.
Okay, so you're, no rule or law or case that stands for you got X number of days to get it out of your office?
Not that I'm aware of.
Okay,
I've also got common sense and a kick in the butt.
I understand that, but that's helpful for me to know because I was looking at it a different way.
Yes, sir.
Commissioner Hyde, if I may also, there are, and I'm sure Judge Bordeaux can tell us, there are specific cases that do have a time limit provided by statute, whether it's carry licenses, for example.
Yeah.
Generally speaking.
And we've,
All right. Thank you, Judge. You can
Thank-
step down. Just watch your step on the way
Yes,
out.
ma'am.
Don't roll down the stairs.
thank you all very much.
Thank you. Mr. Wilson, Mr. Tate, does that complete you all's presentation on behalf of the respondent? Other than closing, obviously.
I think it's still their case, or they're back on the rebuttal.
No? I think that was your last, I thought that was your last witness.
Just to make clear though, we did enter R1 and
I don't know that you all tendered them, but I assume there's no objection to R1 or R2? All right, then R1 and R2 are admitted. Does that conclude your presentation?
Bring up Wendy. I want to hear from Wendy. I want to hear this woman.
I think we've wrapped up before.
Okay. And Ms. Veal, did you say you all had one rebuttal witness?
We do, Your Honor, and she is going to be appearing virtually.
Okay.
So we'll need to get that set up.
And how long do you anticipate as a witness? I'm assuming this is Judge Williamson.
That's correct.
Okay.
I don't intend to recover the areas that we already covered with her. I think I can get through what I need to ask her in 15 minutes.
I'm just thinking if we could get her done and then all we have left after lunch is closing. Are you guys okay with that? Y'all want to take about a 10-minute-ish comfort break? We can go ahead and get her up on the Zoom. The plan being, let's see if we can't get that one rebuttal witness done, and then we'll take.
Because, Jude, I'll tell you why, Jude. YouTube loves to screw with us in every single possible way, every single day. YouTube loves to screw with us. That's what they wake up every day to screw with us. That's what YouTube does. YouTube picks who gets the memberships when you give out memberships. They just do. Sometimes we get real good ones. Sometimes we get ones who participate in chat every single day, blah, blah, blah. And then sometimes we get people who are just passing by sub. Thank you so much. Oh my gosh, you got Linus. Jude, you just got Linus. We're complaining. We're complaining about YouTube and it gives one to Linus. Thank you. All right, guys. I hope we get to hear from. That's Linus. All right. I hope we get to hear from Wendy now. This will be interesting.
Take a lunch break, and then all we'll have left after that would be closing argument, I guess. Okay? So I'm going to stop the live stream for a minute. Feel free to take a comfort break if you need one, and if you will tell me.
I did not remember this happening at all. Hold on. 37 minutes we're at.
Example,
Oh, I gotta go back. I must have.
Are you guys okay with that?
We're not talking about many cases in that
Other than closing, obviously.
38. That's 2 minutes later.
start by first
All right,
thanking
let's go 1 minute
all of you
later.
for your service.
There we go.
Started our live stream back, and I believe we are ready for closing arguments, and understood the director was just going to conclude. So,
Talk amongst yourselves for a second. Because I need to check on something. I think their playlist was backwards. Remember I told you they kept their playlist up? Which never happens. And I was able to get it. I think their playlist is backwards, and all I need to do is find out how long that video is, and they took it down. All right. I'm looking for Wendy. I'm going to look for Wendy, and then we'll come back to this. We're at 38 minutes in the second clip. Closing, 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 closing. I have all the parts ready. That's not normal for me. Let's look at 3. Raven, who would ever think you were a hater? It's downloading. Coffee.
Acting in a judicial capacity on his staff that have been able to hear things. Judge Bordeaux is available. Does not often use the form order. I don't know the answer to that. Be waiting 7 years, 4 years.
It's not part 5.
December of 2024. This was her remarkable that court. I also
court reporter knows. Do you know?
and I would just admit to count 8, which is just December of 2024. This was the under some kind of includes the allegations made in that complaint shall not be used for any purpose. And so if you review, I was willing to stipulate to that, and that's fine. But you have to find willful misconduct in office. Do we need to consider them?
No, I'm just trying to line up, so that we know, because obviously once we receive the transcript.
Judicial misconduct.
To the time you fired Brian Kelly this weekend, and they fired him for not winning enough games. He didn't know. But You know, we're not,
part of requesting this. And again, I'm sure every judge out there would love to have somebody on their staff put that time and effort and energy.
That doesn't make sense. Okay, here's part 3. I don't know if you guys can hear it or not, but hold on. I'll put it in here. So here they're starting their closing arguments. Here's what we're watching right now. This is the next part of their playlist that they uploaded.
November of 2024. This was the very egregious one, 7 years and 4 months. And
You can see this TV is on in here.
I would just note the things in red are the notices, the reminders. So we have
This
Judge
is a
Williamson's
closing
letter.
office.
We have the IP notice to Judge
This is a closing argument, I think.
Bordeaux. We have the subsequent,
It's timely. How do you define timely?
the code doesn't define time.
No, it does not.
He was at the courthouse on those days.
No, Wendy.
Anybody that has access, not with this many that have, but you have multiple people. Judge. Again, there's been an opportunity to have this audit done and to have somebody who is considered, quote, JQC probation. To a specific quarter.
That is definitely not Wendy.
Test 1, 2.
Okay, this is like 20 minutes of nothing, I think. I'm pretty sure. Nope.
To sign it, and essentially the judge has told me he's not going to sign something he didn't write. Another staffing point that I think is important.
That's still her closing argument. All right, that's 3. Let's look at 4. Everything was against us seeing this whole hearing.
Find willful misconduct in office for a judge. Come in. Rule 18 that Mr. Tate.
Okay,
No documents.
doesn't ask you to create documents, it asks you to produce
is that Wendy?
documents already in your possession, correct?
I don't,
I'm
That's a fair,
going back.
Not being paid, but presumably the county is going to have to bring somebody in or some kind of assistance will have to flow to that. court
Doesn't the
to
chief
help them.
clerk become the judge by operation of law?
Well, I guess it depends on whether or not that office is considered vacated if he's suspended. And I think that's probably up to somebody much smarter than me to make that finding or that determination. But certainly Judge Williamson would be there, and I'm sure she would handle what she could. But I think the likely scenario or the reality would be the county paying to bring somebody in to assist for that period of time. And so we are recommending removal. Thank you.
Okay. You guys got any questions? No? All right, thank you.
I didn't want to object in the middle, but I do want to put one thing on the record.
Okay,
And there
go
was
ahead.
some allegation that what was brought in front of the investigative panel about the concealed carry permits should be used in aggravation, and that's a violation of Rule 18 of the JQC rules. Any dismissed complaint cannot be used in aggravation, and I just wanted to put that on the record.
Okay, that's noted. Thank you.
I didn't want to interrupt.
Thank you all. Just a quick question before we close out from, I know we have the transcript from days 1 and 2 complete.
We do.
We do. I think Ms. Beal sent it out to everybody, I don't know, a few.
Do we need it sooner than that?
No, I'm just trying to line up, so that we know. Okay, thank you.
Their playlist is outstandingly out of order. Just like the charges are out of order. Just like Wendy, you are out of order. Here's
Sure,
Wendy.
you have that opportunity, correct?
No, sir, I stated statistics and facts to help him to make a decision in the best interest of the court.
I'm not going to go back through this today because it's in the record and the panel members can read it. But do you recall all of the letters and memorandums and things that you put together saying that the probate court was overworked until Judge Bordeaux decided he was going to run again?
I don't understand that question either.
Yeah, did you put together things for the Chatham County Commission asking for more staff?
For years.
Yes, and then after September of 2023, when Judge Bordeaux told you he was going to run again, you sang a different tune, didn't you?
No. In fact, what happened
That's Wendy. This is Wendy. Judge Williamson or something?
is that we went into a budget meeting because I'd written another persuasive document for the commission. And when we went into the leadership meeting, they told us they were awarding us those 3 positions permanently. And the judge was sitting next to me. And we thanked the commission for giving us the staff we needed and said that we would not ask for more folks in the next budget round, which was the first time since I came on in 2017 that we were not going to ask for an additional person. Unbeknownst to me at the time that we made that representation to the commission with the judge sitting next to me, he was under a 45-day order from the JQC to enter orders or be charged, but none of the staff knew that.
So let me ask you, it's certainly fair. It's certainly fair for the members of the panel to look at your September 25th, 2023 letter and see what you're saying about Judge Bordeaux in there versus what you said in all the documents that you prepared for the county commission when you're talking about the need for more help to get things done in the office. That's certainly a fair comparison, isn't it?
A comparison between what?
Between all the documents that you submitted to the Chatham County Commission asking for more funds and more resources. You understand that part, correct?
Yes.
And it's certainly fair to compare what you say in those with your letter of September 25th, 2023, and to see if those are contradictory. True? That's a fair comparison, isn't it?
I don't think they're contradictory. Number one, they were for different purposes, of course. And I think that the distinction is that I do not believe that staff could have done anything that they didn't do to enable the judge to enter those orders. And I don't think that adding more people.
Well, that's not really the question I asked.
Wait. First of all, yeah, let's let Judge Williamson finish her answer and not talk all over each other. So please finish your answer.
We're always going to need more staff, but more staff would not have made a difference in Judge Bordeaux entering those orders. That's the distinction.
And in your letter, you said they were for 2 purposes. The purposes of your letter was to get Judge Bordeaux out of the office. True?
Well, I'd like to say it this way. My letter was to help him to understand that folks were looking for somebody to run against him and they were going to come after him. And I was hoping he would retire without this trauma.
Did you meet with some individuals about running for probate judge?
I talked to folks at church.
Is that a yes?
A couple of folks, but it wasn't a meeting. It would be in passing to say, what does it take? And I don't have, I'm not political.
You did talk to people about running for probate judge, true?
I talked about what would it take.
Okay.
I did some educational, but after that conversation.
Now, I have asked you, I want to ask you about these documents that you responded to with a subpoena And I first want to have a copy, ask you about the subpoena itself. All before you became a judge.
I just had my 40th law school reunion.
Okay, great. And so you're certainly familiar with subpoenas for the production of documents, correct?
Yes.
And subpoenas for production of documents is a way in which a party to a lawsuit or other controversy gets documents that are already in existence that are in your possession. True?
I mean, there are a variety of things that you could be requested, but
Well,
I
it's a
understand.
subpoena for the production of documents, not for the creation of documents. True?
That's what it says. Subpoena
Okay.
for the production of documents.
And so when you're trying to be responsive to a subpoena, you know, as a lawyer and a judge, you look at what the subpoena asks for and you produce what the subpoena asks for, correct?
Correct.
And so, one more time, it's true that it asks for documents that are already in your possession. It does not ask for you to create additional documents. True?
Any and all documents, including email, related to sharing a spreadsheet, reference in item number 1, tracking related to cases. I don't know where that line,
Yeah.
maybe.
Let's look at the very first thing under the style of the case. Can you read that for me?
Pursuant to OCG, is that what you're asking?
No, but what's the title of the document?
Subpoena for the production of documents.
Doesn't ask you to create documents, it asks you to produce documents already in your possession, correct?
Well, it doesn't use those words.
I do sustain that. She's already said that.
Okay, so what does it ask for? You went by number 1, but number 1 reads, current version as of today of case tracking spreadsheet related to cases or matters with pending orders, decision, action, or review by Judge Bordeaux, correct?
Yes, sir. I interpreted that to be a current version as of the 26th, but I didn't get to do the final research until the 27th.
That's right, but you had a list on the 26th. You wanted to augment that list. That's why you took time to do work. True?
Oh, let me explain how that happened.
Well, can you tell me if it's true or not before you
It's not
explain?
true. It's not
Hank,
true.
wait. There's an objection. What's your objection?
If I could have the witness instructed to give me an answer, I'm perfectly willing to listen to the explanation. But the filibuster beginning without an answer is not acceptable.
I got it. You guys are kind of both filibustering each other. So Judge Williamson, if you would, please just listen to the question asked, try to answer it as straightforward as best you can. Obviously, if you need to explain or qualify an answer, that's fine. But to the extent you can answer the question and then give your explanation, I think that'll go much smoother. And Mr. Tate is not going to step on your dialogue. Okay?
Okay.
You had a list on the 26th, the day that the JQC asked you for the current version as of today. True?
Not true.
So after court that day,
Can I explain?
Yes, go ahead.
if you want to,
So at 4:30, when the subpoena came in, I went back in my office and started gathering the material, and I realized we did not have a current spreadsheet from the June report present. So I went ahead and created that document to begin to work on it. And I needed to go home and go to sleep, at some point. And when I came back, I worked on it further. And I did not know that the judge was going to go, and I'm pleased to know he knows how to go in and see these spreadsheets, but I had not finished the work on that document because I went home and I came back the next day and worked in my normal work day with lots of interruptions because my door stays open and people are coming and going, but it took me all day to fit time in to get it to a final state. And I changed the date in the right corner to the 27th and saved it and sent it. But I had not finished it on the 26th. It was not a complete document.
you added 4 more cases to it.
I added cases that were on the calendar between June and August that didn't have rulings after hearings or that after the hearing, other actions were required. That's what we do. That
Okay.
would have made it accurate.
And you didn't know that Judge Bordeaux was going to get a list that afternoon, which would
Because he
show
didn't ask
you,
me for it.
may I not be interrupted, Your Honor?
I won't
Neither one
interrupt.
of you are giving each other a chance to talk, so just ask what's your question?
My question is, you didn't know Judge Bordeaux already had the existing list from August the 26th, did you?
He didn't have the existing list from August 26th. He went into the folder, the iDrive, which we all share. There's no secret there, and picked up a document I had not finished. I did not know he had the unfinished document.
And instead of providing the existing document, you went and added to and created a new document, correct?
That's, again, I've said that was not the existing document. I had not completed it. I suspect if you look at the document he had, it's identical to the June document, which confirms I had just pulled it up and then I had to stop what I was doing and come back the next day.
Well, your document does not have just cases that involve outstanding orders, true?
Well, if there's action needed by the judge.
Well, for example, scheduled trial, correct?
Correct.
Trial needed, correct?
If the ball is in the judge's court, then it can be put on that list.
And out of what, how many cases do you look through to come up with the ones you put on here?
We go by the schedules.
Beg your pardon?
We go by the weekly schedules that are put together from our case management calendar. And we just go back and look at all the orders, all the hearings to make sure that orders are entered.
And in 2025, you did not provide these to Judge Bordeaux monthly, correct?
I provided them on the dates that you see on the list, but yeah, it's
Only
sometimes
three
it's a
times.
couple of months.
Only 3 times in 8 months, right?
In 2025,
Yes,
that's correct.
3 times in 8 months. Now, did you, when you created this list, you have a date that's the beginning, and that's the date the case is filed, correct?
That's whenever the pleading is filed, right?
Okay, the initial pleading.
But whatever underlying pleading needs a ruling, yes.
Okay, well,
So, wait a minute, you confused me. So that doesn't mean when the case is filed, a pleading is different than the case, is what you're saying?
In other
That would
words,
be-
there's some cases that have like a 2022 case number, but the start date is 2025 or so.
Right.
That start date refers to whatever the most recent pleading in that filed case was that needs action. Is that how that works?
That's correct.
Okay, and then where is the months outstanding measuring from, that other number? What is that measuring from?
That's from the date of the pleading having been filed, whatever relevant pleading it is. And then there's a code built into the Excel spreadsheet that calculates from the date of the report how long, what passage of time. And there's a reason we did it that way, because we wanted to see how long folks were waiting for adjudication of the underlying petition. We wanted the judge to get a sense for how long these things were taking. And that was the way to get that calculation.
Okay.
so let me ask you about that. So let's take the very first one here, which is Blackman, okay?
Mhm.
And you say 90 months pending, right?
Mhm.
And so what you're telling me is that doesn't run from the date of the hearing, that 90 months isn't measured from 2018, right?
It's from 2018.
Okay, well, that seems different from what you just told the panel to me. Can you explain that to me?
No. Well, I mean, you can have multiple hearings and you can bifurcate and take these in little pieces, but the bottom line is a petition for doubtful claim had been pending for 90 months.
Okay, so I asked you, I think I didn't ask you, I think the panel asked you if that initial date was from the date that the order or whatever should have happened, or the date that the case commenced, and you said, oh, it's from the date the order is needed. Is
Wait a
that
minute.
right or wrong?
What I told the panel was that that date is the date of the pleading upon which an order is needed.
Okay,
It's not
so
necessarily the first pleading in the case.
So you have over in the action required, you write hearing held on 11/9/21, order needed. I assume that would be from the 2021 hearing, correct?
That is the hearing date upon which, after which an order was needed.
Okay, and so the order couldn't have been issued before the hearing.
Well, there's some debate about whether you have to have a hearing, but in any event, it could have been if a hearing had been scheduled.
Well, the 90 months isn't from the date of the hearing. The 90 months is from 2018, correct?
From when the petition was filed.
Okay.
So, Judge, is that fair, though, to say it was 90 months pending when it clearly from, no, go ahead.
No, I'm sorry.
From
The
November,
answer is, yeah,
it's not 90 months from November of 21 until April of 25.
no, but what I wanted the judge to understand is that this family had filed a petition in February of 2018. And I know I'm not supposed to look at anything, but generally we immediately appoint a guardian ad litem, and the guardian ad litem will file a report within, months of the filing. And then it starts this long journey where the judge requires it to get to some state of, where he's comfortable, and then he'll do the order. But they were averaging 17 months before they could get a hearing.
So was the Manders case yours?
What page are you on?
It's one of the 4 you added. I think it's
I have
next
to
to
look at
last.
It was not on the calendar as my case.
Okay. Did you enter an order on the Manders case?
I'm no doubt I would have. I sign a lot of orders.
Okay. And when did you enter that order?
I'd have to look at the case management system. Do you want me to look at the case management system?
Yeah. Why don't you look and tell us?
Do you know when I entered an order? Oh, let's see.
I believe you entered it on or about August 27th of 2025. Is that accurate?
No, there was no order entered on August 27th.
Did you enter an order?
Mm-mm.
You
No, sir.
haven't? You said a minute ago you had. I'm just trying to find out if you did or you didn't. You testified you did.
No, sir, I did not. I said I enter a lot of orders, so it would not be unusual, but I had no specific knowledge as to whether I entered an order in this case. I'm looking at the events in this case. There's no order entered on that date.
Okay, is there an order entered on any date?
There's an order entered in September
September
Order
of what? Of what year?
of September 2nd.
Of 2025?
Yeah.
Okay.
Judge Bordeaux signed an order on May 15th, 2025.
And who signed the order of September 2nd, 2025?
Judge Bordeaux.
I thought you said the case was something, maybe I misunderstood.
Oh, I'm sorry. I signed the order appointing the administrator because by that point it had become uncontested. They were able to work out the differences.
Okay. So I just want to make sure.
Hell no, Walter, no way. I can't buy candy before. Is there such thing as stocking up on candy so I have it ready for Halloween? No. I have to buy it that day. You got to know yourself. Got to know your limitations. Yeah, I'm coming to your house. I'm gonna come. It's just one cup, Terry. Just one cup. One cup. Yeah, guys. You know, next week is my favorite week of the year to buy candy. Next week, and the week after is even better. It's like 70% off. Seriously, it's like 70% off soon. Yes, sir. But no, I will not be buying candy before. I'll buy it tomorrow. I said no, Lafayette. No.
Sure, I've got this right. You listed John Manders on there as needing an order for purposes of sending this to the JQC on the 27th, and then 4 or 5 days later, you entered that order, correct?
May I answer? I entered that order, yes. It probably came in a stack of files that had, they had finally gotten a selection by heirs from one of the heirs that had been difficult to serve, and it came in, and so it came in to me on a stack of uncontested, and I haven't updated the list since then, or it would be removed.
That's right. And so you knew this list would be used in the case against Judge Bordeaux, correct?
Of course, of course.
And you've testified at great length about how you wanted to make sure it was updated and it was all current, correct? That's the reason you
was
went
on the
home and came
27th.
back the next day, true?
That is correct on the 27th.
Okay, and so did you ever go back and tell the JQC that the order was entered on that one?
It's because my microphone was standing at attention. I have to bring it back down again. There we go. Sorry.
No, because I when asked to update it,
Okay.
and I'm trying to do a job.
Well, were you asked to include it on this list?
It was at the time that I entered it on the list on the 27th of August. That's an accurate description of the state of the case. And what happened is after that hearing, I believe they went out and they were able to locate an heir.
I don't know
And
who's they. Who is they?
The parties were able to address whatever problem had been identified that was keeping them stuck. So in the order that the judge entered on May 15th, he said that there was heirs had not consented.
Well, let me just kind of cut to the chase here on Manders for a minute, because you understand how one of these panel members looking at Manders now, one of the 4 cases you add, looks over where there's a big 20 and thinks this case is still open out here. True?
Well, on the 27th of August, 2025, that was an accurate explanation and description. And I didn't know that in 5 days it would be in a stack of uncontested cases. And I have not sat at my desk and looked at this list every day since August 27th because I'm trying really hard to get orders out on time.
It just wasn't clear to you?
You know, I sign a lot of orders.
Okay, well, you do try to be accurate in what you put in this document that you created to send to the JQC, right?
Yes, sir, and it was.
Okay, well,
Just so everybody knows, Josh, I appreciate you. I just appreciate you.
let's talk a minute about the Richardson case. Richardson is 2 above the 4 you added.
Yes.
All right. So there was a bench trial scheduled for July 24th, 24th, 25th, 2025, and that was vacated, and it says need to reschedule bench trial, correct? Now, do you know why a bench trial needed to be rescheduled in that?
If you want me to look, I can go look.
Well, what if I told you that it was because there was a motion to recuse and it was referred to a Superior Court judge and the Superior Court judge granted the motion?
I'd have to see what timing of all that was.
Uh-huh. Well,
You didn't check that before you made the list?
This would have been on the list a long time ago. I'm not sure, that would not have been put on recently.
Well, did you not, when you update it, you just add on? You don't ever go back and see what happened to the ones you listed before?
Yes, sir. I sent to the JQC a list of resolved cases too. So, I mean, we were moving cases over to resolve when they were resolved, and we didn't, bear in mind that the judge had access to these and was provided these and could any day have walked out to my office and said, hey, I see that this one has been resolved, or this is inaccurate, or anything. I would have gladly modified these, but we took a picture at
Yes, Crystal. This is the judge that is trying to get his spot. This is no, you gotta leave. This is the judge that wants his job. Oof.
the time that the reports were done to give him a picture of what was outstanding. And yes, I would have taken
So-
note. I
so
don't want to
are-
put things on here that aren't
Just tell me when
accurate.
you finished, and tell me when you
I'm
finished,
finished.
and
I'm finished.
okay. So you're telling me today, after having told me that you tried to make this list accurate, that Judge Bordeaux could have told you it was inaccurate and you would have changed it. Is that what your testimony is?
He was welcome to participate in this that was the whole point. Yes.
Well, do you agree now, sitting here today, that it wasn't Judge Bordeaux's fault that the Superior Court ruled that he should be recused?
Can I look at the case? Because I really don't know. I don't know these cases. I mean, we have a lot of cases, so I'm going to have to look.
Well, I understand, but we only have 2 pages.
And the bad part about that, JK, stop. She is able to see his caseload. She's able to critique his caseload. She has it all in a list. She keeps track. He is not keeping track of her caseload. He is not keeping it in a list. He is not going into that content management system. I'm telling you right now, I'm going to put you outside. Thank you, Anna. So he is not able to see hers because he's not technologically or vindictively at that level. Her caseload is just as bad.
Here, and I understood that you went through this with such great depth that you had to go home, rest, come back the next day. So I'm not talking about the hundreds of cases in the office. I'm just talking about the ones on this sheet.
I know. I still am looking to see. May I look and see what happened?
If you'll tell us what you're looking at, yes.
I'm going in the case management system to look for the Richardson case, to look at the timing of all this. So the order of recusal was entered in October of 2025.
It had already been referred over to the judge, though, then? The order granting the recusal may have been, but the case had already been sent over to the judge, to the Superior Court judge, true?
Well, I think in that particular case, it went over and it came back with a denial pretty quickly, and then it came back again on a recusal. So in August, there was no recusal.
I understand, but it had been sent back to the Superior Court judge in August to determine the second or third motion for recusal, correct?
No, sir. I think the motion to recuse was filed in September.
So there was no hearing on the motion. It's all paper.
Yeah.
The first hearing was prior to that, and it was a denial. And then the second motion to recuse was filed September 11th, 2025, and was ruled on in October of 2025, last week, 2 weeks ago.
Can I have just? So there were 3 motions for recusal, correct?
Well, there was one motion for recusal in this case, which is about a power of attorney. And then there was another one in this case filed in September. And then there was a third that was filed in the guardianship case that had been filed at some point during this. But not 3. I don't think there were 3 in this case.
So, but you didn't note any motions to recusal in your notes there, did you?
No, I think that may have been just a matter of timing, but I would be certainly aware of that and would not put on this list a case that had gotten recused.
Nonetheless, it's there. May I have one more moment? That's all the questions I have for this witness.
Anything else, Ms. Beal, before we let Judge Williamson log off? All right, thank you. Thank you, Judge, appreciate it. Does that conclude the rebuttal evidence?
I do have one thing. I believe.
Well, hang on, I'm asking Ms. Beal, does that conclude your rebuttal evidence?
Yes, Your Honor.
Okay, and did you have something you wanted to offer
Yeah,
into evidence?
I wanted to make sure, I believe that this letter of September 25th, 2023 was in evidence.
It's in evidence as P1, I
I
think.
think that's correct.
Yeah.
I just want to double check if it wasn't while I had the witness. I want to make sure that it was.
I had it in my stack with my copy as P1 last time, so I think it was
In
in
the
it.
interim, my stamped copy got lost.
I gotcha.
I apologize.
Okay, all right,
I'm sorry to interrupt. I
Yeah.
have one additional exhibit.
Okay.
I know I said that I concluded my rebuttal evidence, but I need to enter P27 into evidence, and I spoke to Mr. Wilson about P27.
any objection to P27? That looks like,
It's the emails that Judge Williamson sent me with the documents attached to it. It's just the email that I sent y'all in response to your email.
all right, so P27 sounds like is in without objection. All right, does that conclude the evidence portion of this hearing? Yes? Okay. Well, why don't we take a lunch break? We'll resume at 2:30 with closing arguments. Ms. Beal, for planning purposes, are you planning to open and conclude or just conclude? All right, who's doing the closing? Mr. Tate. So Mr. Tate, you'll be up at, when we come back to finish closing arguments.
What time are we coming back?
Let's take an hour, and, try if we can to be back at 2:30.
Okay. Now it looks like I have to go back to the second one. To 39 minutes? Is that what it was? To start closing arguments. No, Lafayette, stop. No, no. Oh man, I was really close, guys. Look how close I got.
Started our live stream back, and I believe we are ready for closing arguments, and understood the director was just going to conclude. So, Mr. Tate, it's to you to close when you're ready.
Thank you, Your Honor. I want to start by first thanking all of you for your service. I know from firsthand experience that it's not high paying, and it's not always pleasant to have to deal with these things, but I appreciate it. And I did. I think Judge Lopez and Judge Burleson, y'all been judges before. I've never really been a judge except when I sat on the panel, but I did learn that stem-winding oratory is probably not the way to go. So I just want to talk to you a little bit about the facts here. And I think maybe the last time I argued in front of Mr. Lopez, you asked me one of these questions, which was, you sat up here one time, what would you do about this? And that's very helpful to me because it kind of tells me things you want to hear, and I'm going to try to address that as I go through it. So to start off with, I think I would be remiss if I didn't point out the fact that this is sort of a case like no other. I have seen a lot of judicial discipline cases, represented people in judicial discipline cases. There's no allegation of wrongdoing, of abuse of power, of anything. It all has to do, in this case, with whether the orders were gotten out quickly enough, who was at fault in doing that, and it's really just a failure to rule case. And my client in this case, as I noted in our opening, is not someone that I think anybody feels is incompetent to do this job. He was an accomplished lawyer, was a state legislator, chaired the House Judiciary Committee for many years, has been a dedicated public service servant, so nobody doubts his ability to do the job, and I don't deny that he has the ability to do the job. And in the answer, in fact, to this case, as to the factual allegations that were made, the case was ripe for an order on this date and an order didn't get out a certain date, we really haven't denied that. We admitted that from the very beginning. So what is really the evidence that you need to look at here? And I would submit that there are still a number of evidentiary considerations that need to sort of be brought to the forefront. There's 16 cases that are charged here, and I think we said in opening, and it's in the record through the applications that were made for additional funds, that in 2020, for example, the caseload, the number of filings in the Chatham County Probate Court were 14,681. In 2018, in the budget request, it shows around 2,000 orders issued. There were 2,177 cases total. 229 of those were probate orders, but almost 2,000. 1,948 were actual probate orders. And so we're talking about 16 cases out of about 2,000 that are filed in a year, and that is less than 1% of the work that the probate judge does there. I'm always glad when we have a little break.
That completely pisses me off. I mean, okay. That case has sat for 7 years. Okay, that's really bad. But if any of us did, only less than 1% of our job was bad, we would be, when I work every day, not every table is 100% every day. Every day, and I don't have 1,000 tables every day. Oh man.
And I can go back and look at the evidence, but I also know that it's easy to sort of forget evidence. And Commissioner Hyde asked the question earlier when Judge Bordeaux was on the witness stand and said, well, did you ever go ask for more stuff? And he did repeatedly. There are a number of exhibits, and I'm just refreshing your recollection, because it's in the record where he went back and again asked for additional staff. He asked for additional funds. He asked for additional space. And all the time, he's dealing with what I was sort of taught in college economics, sort of the bathtub theorem, where what's going out down the drain and what's coming in through the spigot, you're still raising up. And to clarify something that I think he's testified to again and again and again.
I think this is crazy. I just think that 1% is crazy. So what percentage is he allowed to, not be perfect on when he has that many cases? That's well over 3 cases a day.
But as somebody who doesn't do a lot of probate work, it kind of shot over my head. But when he says, oh, I had emergency stuff or had other stuff that I had to deal with, these are the things where you come in and, my grandmother's fallen and I need to get a guardianship for her. And so you've got to kind of stop what you're doing and go and deal with these. And so those are the things that he went to deal with. And I know other courts have those. I know as a Superior Court judge, you get temporary restraining orders and you get emergency child custody issues and you get TROs and things in business. But this is sort of a steady flow of these things that are coming in all the time. And so he was behind on 16 cases, at least 3 of those, by the way. I looked at Adger, Petty, and Deering were during the COVID era. And those were during times that, the courts were shut down, were operating under an emergency order. And for purposes of looking at that, I really just looked at when the judicial orders, were in place. But there was an extension of 18 months, that was in place on those. And the other thing that I think we brought you evidence about is that he's not a slackard. In fact, I would think that if he were nominated to be one of the hardest working judges in Georgia, we'd have a pretty good case. And one of the ways that we showed this is a way that traditionally the JQC, during my affiliation with it, went to look to see if people are really showing up for work. This was before people, worked from home or did things from home, but we'd go get, let's go see if you're in a government building. Let's just see how often you're there. And we went back and we pulled 7 years of data from 2018 to 2025. And over that time period, there were only 1,884 working days. That's Monday through Friday, 9 to 5. And Judge Bordeaux was in his office for 2,175 days, which was 15% more than the actual working days. He was in his office for 58% of the Saturdays. He was in his office for 75% of the Sundays. And you heard, in fact, his testimony. His wife's a minister at the church, and he would drop her off at Sunday school. He would go work, and then he would try to go to church. And when he was in his office, Monday through Friday, he got there before 8, 17% of the time, and stayed past 6, 96% of the time, past 7, 50% of the time, and into the wee hours, that's after midnight, 13% of the time. So here's somebody that's going to the office, who's working hard, and who's frankly earning their paycheck. And still there were many orders that he did not get out on time, and he's been perfectly candid about that. But I think one of the things that I'm going to talk about here in just a minute is sort of what the standard is for discipline. And it's not a res ipsa loquitur standard. The thing speaks for itself. Even the statute that we've talked about here that's clearly applicable to Superior Court judges is population-wise. I think the longest is 90 days, and that's if you're in a county over a certain size. But even if you go past that, and you're a Superior Court judge, and you're in a county, you go past the applicable limit for your county and getting an order out, you're not automatically in violation of the canons of judicial conduct. It wasn't lost on me that LSU fired Brian Kelly this weekend, and they fired him for not winning enough games. He didn't accomplish his goals. For a public servant, and again, Judge Bordeaux was reelected after these charges were filed and after these charges were out there with over 61% of the vote. And so the people of Chatham County knew who they were electing and they knew who they were re-electing when they did that. And I think that's not an insignificant fact either, because we've chosen to have elected judges here in Georgia. And when you're talking about removal, which is what the director is asking for here, you're talking about undoing an election. And undoing an election that was won not just by 50% of the vote or 51% of the vote, but by 61% of the vote, overwhelmingly so. And I think the Constitution reflects that. And I have had a long-term friendly debate with those on the other side of judicial discipline. They frequently say that someone lacks temperance, and you can be removed for intemperance, but if you look at the case law, that really means that you're an alcoholic or a drug abuser. It doesn't mean that you're a bear to deal with, when you're sitting on the bench. But they're actually constitutional standards, which would certainly trump the rules, trump the canons, and I don't think they're really in conflict here. But what the Constitution, Article 6, Section 7, Paragraph 6 says is that a judge may be suspended or removed for willful misconduct or for willful and persistent failure to perform the duties of his office. So it has to be willful, and it also has to be persistent. What the evidence here is, which, in terms of the number of cases, is that about 1% of the 2,000 cases there filed each year, there was a late order that came out. What the evidence also is that in the 2018 letter, the one I was speaking about with Commissioner Hyde earlier, in that letter, he writes to the Chatham County Commission, and he says, in essence, we're about to have a judicial emergency here. I can't meet the demands that are being brought to bear on this office. And so when the director says, oh, but you've now doubled your staff, that doesn't do anything to do away with the backlog, and it's still short, and it's still insufficient, and they were still asking for more and more and more. And I would call your attention particularly to the testimony of Pat Moynihan. He was very impressive, was the retired assistant city manager, and he went through and did an analysis, and he compared Chatham County to other counties that were similar. And if you look at what he found, and if you go back and look and read his testimony, what it shows is they are, in fact, understaffed.
Yes, this is Jasper County. This courtroom is Jasper. However, it's Georgia, and they do not have a lot of courtroom space. All the judges are saying how much they do not have courtroom spaces. Remember the other judge that we watch all the time, and I don't know what his name is? He had those 17 co-defendants in the RICO case, and they couldn't do it together because there was no courtroom space available for that. This judge right here who's in trouble is complaining they do not have the courtroom space. They have tiny spaces. So this panel of judges, I'm positive, doesn't have their own dedicated courtroom, to work in. So they must just get whatever they can around Georgia when they have one of these hearings to do. So they are doing this hearing in Jasper County, 100%. But that doesn't mean this judge works at Pickens. He probably does. I don't know why they keep referring to that other county. I don't know. So I watched that Chatham, is that what it is? Is that how you pronounce it? Judge Tammy Stokes is there. We see her. Remember the Treehouse bar where people were getting shot at, that is Chatham County. That's Tammy Stokes, and there's 2 other judges there. He's never on the list there. But he's probate, and I don't do probate that often. I really still think that he works in Pickens, so with Jasper County, this judge right here. I think they came to him. But probate court, he might do. He was elected in Chatham County? Chatham. He was elected in Chatham County? Did you look that up? He was elected, and because I really thought it was Pickens, that he worked in Pickens. Anyway, so I don't know why they keep talking about that.
And none of that even takes into account the fact that from the first day Tom Bordeaux walked in, he walked into a mess, and he walked into a mess that, at least for a small time, got worse and not better. The prior probate judge had cruised along. His chief clerk was going out and opening accounts and taking money, stole over $1 million, was prosecuted. He had Nat Rackett with him, who he'd hired to be his chief clerk, and 6.5 months into his term, Nat Rackett dies, leaving not only an emotional pall over the office, but also he loses the person that's trying to help him get control of all of this. Now, the standard for the burden of proof is clear and convincing evidence. And so when the director gets up and talks to you about clear and convincing evidence, there's no contrary evidence that they were understaffed. There's no contrary evidence that they were underfunded. There's no contrary evidence to the time that Tom Bordeaux spent in the office. There's no contrary evidence to the numbers here. And so we had a number of witnesses that got up there and said, yeah, the probate court's slow, we may have to charge some people more. But the only person really saying that this is all Tom Bordeaux's fault, instead of, it's a combination of things. Tom's got some fault in it too, not trying for 1 minute to say that he doesn't. Wendy Williamson is the only one that's saying that. And Wendy Williamson points the sole finger to Tom Bordeaux. And we did talk over each other a lot, and maybe I filibustered as much as she did, but I'd urge you to go back and read the cross-examination of her in the original hearing that we had in Savannah, and read what she said. She refuses to deny that she met with people about running for probate judge. She says, well, I probably talked to some folks about it, but I really probably wasn't going to run. And I think she wanted to run unopposed. She wanted to be the heir apparent in that office. And so in September of 2025, she goes and meets with Tom. And I want you to read that letter again. Read it 3 times, please. I wanted to make sure it was in evidence because it's plaintiff's exhibit number 1. But she begins it by saying, thank you for meeting with me. I shared with you that I was not supportive of your seeking re-election due to recurring problems causing harm to the court and the public. Now, when you read this letter, it reads like a brief that Ms. Veal in her office might put together. It's got footnotes to the official code of Georgia annotated, the court's title to impartiality and fairness, and the Georgia Code of Judicial Conduct. And she says, I just like to document things. She takes pictures of Tom Bordeaux's private office, of his chambers, and I didn't think it was that bad. It looks about like my office. But we all have our own office way of keeping things, and whether you're a public official or whether you're a private attorney, your office is where you go to do your work. And so if you go back and read her testimony from the first part, and if you read her testimony after it's transcribed here today, there were parts that it sounded like an argument that would be given in court, like an argument that would be given in court if you're sitting where Ms. Veal was and you're trying to make the case against Tom Bordeaux. I don't know. I don't think I've ever talked to a lawyer that thought when you got a subpoena, you went to sort of prepare documents for somebody instead of gathering those documents.
Raven, no, that's the whole problem. He didn't rely on anyone else. So he did a hearing and he verbally said his decision during the hearing, but then he did not go and type up the order and enter the order into the file. So if it was criminal court, let's just say it was criminal court, and he found this person guilty, this person innocent, blah 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 blah. He did not type that up and put it in the file when the hearing was over for years. And the reason why is because he wanted to write the orders. He wanted to explain his decisions instead of just saying order granted or order denied. He wanted to write the order and explain it. No, he said it. He said it on the stand. He didn't want help from other people. Other people offered him help. Many other people offered him help. And he did not want them to help him write these orders because he said that's not fair to, the people in the case, that they don't have his decision and his thoughts on his decision. And he also said it would make it really hard on appeals because his decision had to be detailed enough so that when they went to appeals, the appeals board had something to look at. So because he wanted to put all this information and all of his decisions, then he wasn't able to get as many decisions done as they wanted him to.
And you have before you what Judge Bordeaux sent us when we walked over there at 4:30 that afternoon, and then you look at it after she says she goes back and prepared it. And by the way, she knew we had that because we try to play fair. We sent them the original without those final 4 cases yesterday. So she knew exactly what I was going to ask her about today, and she added those on. Now, it would make your job maybe a lot easier if there's just a docket, if there was a docket that was in this case, and that, you could just look and say late, on time, late, on time, on time. But that's not what that was, and it's not what it was ever intended to be. It was something that she came up with and that she started keeping after they lost one of their assistants. And although she testified she was going to give it to them once a month, I think it was 3 times, in 2025. So this is not, I would submit to you, clear and convincing evidence of any violation of the canons of judicial ethics on the behalf of Judge Bordeaux. And in fact, if you look at one of the rules he's charged under, Rule 2.2, impartiality and fairness, which says a judge shall dispose of all judicial matters fairly, promptly, and efficiently, you'll see that what is there in the comments is not the standard that would apply to Brian Kelly at LSU. You've got to win these many games. You've got to get this. It says prompt disposition of the court's business requires judges to devote adequate time to their duties. He devoted more than adequate time to his duties. To be punctual in attending court and expeditious in determining matters under submission, and to insist that court officials, litigants, and lawyers and their lawyers cooperate with court to achieve that end. I think that's what he has largely done, in this situation. And so we come around to the point where I want to talk to you just a minute about, so what do you do? What do you do with this case? What are the options that you have in this case? Well, we've been told, and one of the reasons we're here trying this case is because we've told them, well, the investigative panel wants to remove Judge Bordeaux. We want to remove him from office. And I would submit to you, first off, that there's no willful and persistent failure to perform judicial duties under the Constitution such as would permit that. But I also want to show you or talk to you about Rule 6B, which involves sanctions. And in the comments, it says removal or suspension are the most serious, and their use only appropriate when the respondent's misconduct demonstrates that the respondent is unfit to hold judicial office. So suspension and removal are only appropriate if you find that Tom Bordeaux is unfit to hold judicial office. I would submit to you that that's quite a stretch. I would submit to you that it's quite a stretch. But you also have, under Rule 6B8, it permits other appropriate disciplinary action. And in particular, one of the comments, comment 3 to that says, is that, and I am going to venture into technology for a moment here because I had it up on my iPad. It says, in many instances, however, judicial conduct is of a lesser nature that does not require the judge's removal or suspension. And I think that's applicable here because the other comments I've read, either to protect the public or to preserve the integrity of the judiciary. The facts may indicate that a judge can continue to serve effectively with certain limitations, e.g., limitation to a specific court or docket or participation in therapy, counseling, or recovery program. In these cases, the hearing panel should recommend and the Supreme Court should exercise its inherent authority to fashion appropriate limitations and conditions. Again, that's comment 3 to JQC Rule 6.
No, Josh, remember, these charges came out before he was elected. So, again, the last election that he won over 60% of the vote, these charges were already out. Everybody knew about, all the voters knew he had these charges pending, and they voted for him anyway. So it didn't help Wendy. It helped the judge, I guess.
B8. So what we have here is a situation where he's unquestionably behind, and if you're
Who else just wanted him to say is a failure to communicate there? That is a lost opportunity, sir.
the investigative panel and you sent him a letter and said, catch up on all these cases, and he's got guardianships and other stuff coming in, and he doesn't get caught up on the cases, you're upset with him. I get that. And if you're on the investigative panel or you're on this panel, what you want to happen is to get this thing back on track so you don't have to deal with it anymore. And we don't have a JQC jail, but we don't have a JQC probation office either. But I would suggest to you when I first went to Judge Bordeaux and was talking to him about his case, what's the problem you get caught up? And he says, Lester, the work is such that I will probably fall behind on something else. If I'm held to, like some strict timeline with no explanations, no excuses, he said, I'm just postponing the inevitable here because I know the nature of the job because I have done it. And so I think, and I said to him, I said, you need to be diligent in this, but if you're not, you need for some independent person or group of people to know, so you document it or you get more help or you have a fallback plan that does that. And so what I am proposing to the panel, and what through stipulations and everything I think we have put before, is that Judge Bordeaux would engage Pat Monahan, who you heard, the retired assistant county manager, to perform a management review of his office and to provide ongoing direct review of case counts and order completion rates. Now, what I think Pat would be able to do, because of his experience in local government, is to provide you the list that this other list today was portrayed to be, but which it is not. But an actual definitive list of what had been done and what has not been done and what needs to be done soon.
Are you saying the hearing panel would get that list and monitor it, for lack of a better word?
Can I postpone your question for just a minute and put it, because I want you to ask me questions about this. I also talked to Judge Chase Doherty, who is the former probate judge council president, who's widely respected, and he agreed to go over those in order he would get the list. He would go over those. He would confer with Monahan to make sure it was accurate with Judge Bordeaux, and develop a plan that ensures that any order that is not completed within 120 days is identified, and that Judge Bordeaux will consult with Judge Doherty and will develop a plan to ensure these orders are completed as promptly as practical, specific to the circumstances of the case. And Judge Doherty agreed to report to the JQC on a quarterly basis regarding his consultations with Judge Bordeaux.
This guy keeps talking. Shit is about to go down at my house any second now. Like a family shit, like big deal. Like fighting. Not fighting, but fighting. And I'm trying to get to my OJ stream, but this guy keeps talking. I hope he wraps up soon, because literally I'm dying sitting here right now.
And bring to the JQC's attention any instances where he feels Judge Bordeaux is causing unreasonable delay. Judge Doherty will also assist Judge Bordeaux in getting assistance from senior judges or from others as may be required. So back to your question, Commissioner Hyde, he would submit it to him, and what I'm trying to do, you all would have access to it certainly, if you wanted him to file a report or however you wanted to ensure monitoring. But I'm not trying to make y'all go down, and sit down with the probate court. That's not fair to you all. And again, Judge Bordeaux has indicated to me that he is willing to pay Mr. Monahan, and to the extent compensation is appropriate, given the judicial conduct, but it's extra work. And I think Judge Doherty may do some extra judging in municipal courts or other probate courts.
Sharon, I know he said he's not running in 2028. However, did you hear what he said? He has a daughter in, what college did he say? A very expensive college, law school. He has to pay for that. So, who knows if he's going to run?
But that's what we're asking you to consider in this case. And we're asking you to consider that because there are a lot of factors that go into this. And I've told Judge Bordeaux, if you have to go back to the county commission to ask for more folks to do this, you're going to have documentation that's going to prove this. If you get in a situation, and Commissioner Hyde asked several questions about comparing it to sheriffs, because they're constitutional officers, just like probate judges are. And there have been instances, as you all know, where there have been lawsuits filed about inadequate funding or whatever, but you'll have that if that is in fact the case. And you'll have somebody looking at it that's willing to look at it and frankly knows enough about probate law. Now this is an Article 6 court. That's not an Article 6 court. But I think that
You're talking about Cook County.
Cook County is not, yes, Cook County is not an Article 6 court. But we believe that's an appropriate solution in this case. We also believe that it's one that you have the ability to set in motion because of what the rules say. We do not believe that this is the kind of case that contemplates removal or suspension. You also heard Judge Bordeaux in response to questions about what he thought ought to happen. He feels he played a role in it. He's willing to accept reprimand if that is the will of the panel.
He said private reprimand though, didn't he? Or did he say reprimand?
Well, he said private reprimand, but he was talking about his daughter reading it, so I perceived he probably meant a public. I mean, usually when we're at this stage, we don't have a private reprimand because the public's looking to you all for a decision, in this case. So I'm happy to answer any questions that y'all have about that.
I have a question. So
Sure.
suppose we were to go along with the plan you're proposing, and we do in fact get to the point where, despite his best efforts, Judge Doherty finds himself in the position of having to let Ms. Veal and the IP know, look, we're past 120 days on all these need attention. I've told them that they haven't been done. I guess my question to you is, and then what? I mean, do we just start this whole process over again where they have to decide and investigate and pull all those documents and file new formal charges, and then we go through, because I would imagine then they really would be seeking removal, and we go through this whole process again? Or is your client willing to say, look, if I find myself back in the situation of having to be reported now by my probation officer, Judge Doherty, to the JQC, I just agree to resign at that point? I mean, I'm just, or are we just starting the process all over again?
Well, couple of things. I mean, as every one of you knows, in the standard in probation revocations is slight evidence, and I don't know that I can change the rules of judicial conduct, but I'm certainly willing to agree to some sort of expedited thing. But the other thing I think is, just having tried these cases before, there ain't much question. There's just not much question about that if he's still behind on this, because he's had somebody had two people that we selected that have gone through and have come back to that. And so, to my way of thinking, that's not even clear and convincing evidence. That's probably beyond a reasonable doubt evidence, at that point in time.
Maybe, but we agree that the director and the investigative panel would still have to go through the process of charging and all that. Or I guess my question is your client willing to just say, look, if I get there, I'm done. I'm resigning.
In the past, I remember one case, Mr. Tate, specifically, painfully, that it was a state court judge, and I was not a member at the time. And the state court judge entered into an agreement before we had two panels where they waived any type of fact-finding, and it would just be a sentencing procedure, that if I do X.
I think I participated in that
You
one,
did.
as I recall. Well, I have an answer to your question provided by my client, and I will read it verbatim, and if you want me to make it an exhibit, I will. It says, I will resign if more than 120 days late on getting order out after a hearing. So there's your answer.
Today, like, is that his work starting today?
If y'all are agreeing to have Chase Doherty and Pat Monahan, look at it, and if they find that, yes, but we're not agreeing to that. If the idea is we're going to continue to have, Judge Williams be the decider about it.
What would you be expecting of the director and the investigative panel with this? What would you be expecting the investigative panel and/or the director to be doing while all of this? Are they the ones that come back to us and say 120 days, or does the judge, you guys submit something to say?
I think if Judge Doherty looks at it and says, you know, he's got, and you know, my proposal is they're unreasonably late. You know, there may be some reason, like the judge recusal or you know, some situation like that prolongs it. But I think if he goes to him and says, look, Judge Bordeaux's not getting the job done, I think that's, you know, they may have a role to vote that, but I don't think there's.
Who's going to investigate to see if there was a reason for the going over 120 days is my question. Does Doherty do this?
I think what I was, in my proposal, I'm telling you what I'm proposing,
Right.
you know, you don't have to take every bit of it or none of it, but what I was saying in my proposal, I thought with another judge looking at it, if it's over 120 days, and, you know, then says, why is this? And send me the papers or whatever, and says, you know, yeah, that's legitimate. You know, this case is because it's been over at the Superior Court for 6 months while somebody decides a recusal motion. You know, I think you're having somebody that knows probate court look at it and determine if that's the case. You know, probate court's the one where if you had a mother died in childbirth in a medical malpractice case, you got 18 years of an open case with the minor. If somebody gets incapacitated when they're 18, you have till their death, you know, where it's over. So there's some cases that might have unique features. I don't know what all those are because I don't do enough probate. But
That's explainable. I'm wondering if the Cook County probate judge, and I don't remember if Chase is or is not a lawyer. I don't know.
he is not. He is not. And I called him because of my acquaintance with
I'm not
him.
saying that's a negative.
Yeah. Well, it hadn't been a negative for serving on the.
So
on the panel.
I'm wondering if it's appropriate, though, if we were to consider that it's a bigger county as opposed to Cook County, Adel, Georgia versus Marietta and Cobb County.
Mm-hmm.
Then you'd have to draft a judge into being the monitor, for lack of a better word.
I didn't. I called him and asked him. He did not have my prior relationship with him is
No,
what I
he's
asked.
jam up. There's no
And,
question about
but
that.
I felt like his integrity, you know, and that was not in question. And I felt like, for me to come here and ask you to consider this without having some, you know, some assurance that somebody somewhere would do it isn't appropriate. But if you believe it ought to be a member of the bar, you know, an Article 6 probate judge, you know, we certainly don't object to it.
I mean, you're hitting us cold with this, so I'm just thinking out loud.
I understand. I understand.
This
And
is
I do, again, though, want to emphasize, what I've tried to do is just set up a framework here and make sure I had some people that were willing to fill that, you know, out there. And, you know, y'all don't get paid the big bucks, but you're the ones that get to decide this, so.
No, I appreciate parties coming in here and telling us, short of removal, here's some proposals, because not enough of y'all do that. I just have to smoke this one over. I've got a lot of questions about it. I'm obviously interested to hear from the director.
And you know, the last thing I'm gonna say, there are no perfect solutions to this or any of these, you know, any of these problems. You know, there is, as I think Commissioner Lopez, you know, identified, there's some strife there, you know, in that office. But that also causes a problem too, because I've been involved in enough JQC investigations when somebody's given the JQC information and you, as was asked of Judge Board, well, you're the boss. You know, you can tell somebody what to do, or you can tell them to pack their bags, whatever. It's not a good situation for firing an employee, you know, it would be cast as you were, you know, firing them for telling the JQC the truth. I mean, you know, it's a difficult.
But Judge Bordeaux's comment, I think, was undermining.
Yeah.
I don't, at my law firm, if a partner had a paralegal that was undermining that partner's practice, that'd be the last day the staff member worked there.
If I were the probate judge, I think I would have done something different.
Are they telling her to fire Wendy? Him? Are they telling him to fire Wendy? Yo, Judge, she needs to go. Okay, I don't. Does that sort of say they're leaning some way? Some sort of way in their verdict? We don't know. We don't have the verdict yet. They still have more to do before we get the verdict.
In this situation, but I can't say that what he did is wrong, but.
No, but as I recall, you've had the same staff people for 40 years.
I have. Well, actually, 30. My paralegal just hit 30 years with me, and the other one's at 29. So I'm very proud of that. But yes, but it's easy to see solutions. It's harder to implement them. I get that. Let me thank you again. Is there any more questions before I say? Thank you again. I really appreciate that you all have listened to this. It's always a pleasure to try cases in front of you all. Thank you.
Thank you, Mr. Tate. Ms. Field?
Nobody wants to hear from you right now. We're on a high of them telling him to fire Wendy. We're going to ride that high the whole way until tomorrow before you stand up and then they start making comments that make us feel that they're on your side, because that's what those judges do. They talk to each side differently. So, okay. So, he probably already fired Wendy. Let's just think about that. He probably already fired Wendy. And today is a new day for him. Dude, what if though? What if they're like, okay, bet Wendy's going to start observing your list, and if you go over 120 days, Wendy will let us know and you can resign. All right, guys, I got to start OJ. I will see you all again really, really, really soon. Stick around for a great song. Thanks for coming out today, guys. I appreciate it. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. see for yourself.